Hello there. The following is a recording of our second lecture. For the first lecture, I sent over the slides. That was just an introduction into how you can prepare a witness. We will talk about the system that we learned during that class more extensively later, but there is a PowerPoint on that, and again, we will discuss this later. Our topic for today is going to be objections. This is a crash course into objections and more specifically a few functions. How do objections actually work? Now, why are objections even possible to begin with? Isn't that kind of a disruption to a proceeding? Well, Rule 103 of the Federal Rules of Evidence outlines those objections. Essentially, there is some evidence that has an impact on an individual's rights. During a trial, during a legal proceeding, parties have rights. They have a right to due process, they have a right to a jury trial. This depends on the case, but there are rights of that party, and those substantial rights, so rights granted by the Constitution, for example, but also simply rights granted by the process of the case, are a point of interest for said parties. It's an interest to point out violations of those substantial rights because, well, it's your rights that you want to protect. So objections are simply you pointing out that some evidence, so that specific evidence, affects your substantial rights. But that alone is not enough. When objecting, you must also state the specific ground for why you're objecting. So it has to be timely, and you have to explain why the evidence affects one of your substantial rights. There's also a value on appeal for objections, where a claim of error in a ruling to admit or exclude evidence, so an objection basically, hey, we shouldn't admit this, or hey, we should admit this, um, is essential for an appeal later. If based on that piece of evidence being excluded or admitted, you lost the case, or the case was in an unfavorable outcome, you can appeal the case, but only if you voice that objection. So if you did not object, and this piece of evidence that you didn't object to, say, cost you the entire case, well, sorry, you should have objected. So on appeal, you'll have a much, much greater time. It'll probably even be impossible. Of course, once a court has ruled on your objection or whatever, um, you do not need to renew it. You do not need to renew your protest against said evidence. So you do not need to resubmit, to repeat yourself, basically. Now, admittedly, there are various grounds for objecting. This depends on cases. So you can object for various reasons, for various of your substantial rights being affected. And memorization only brings you so far. I mean, there are objection cheat sheets on the internet, but looking up the specific objection, so how to object, like objection argumentative, objection hearsay, whatever, looking up the specific objection and its definition can be risky during a trial. So, wait, Your Honor, I have to review this quickly. Instead, what I recommend you to do is build a system of tests. Instead of looking through each objection, each ground for objection one by one on a cheat sheet, I recommend you find questions, so tests, to exclude as many possibilities as you can, as many grounds as possible for objection. So you have a question, and with a simple test, you exclude almost all of the objections and you're left with only a few, and then you'd have to decide based on context. One way to do so is by, say, during a witness examination, because objections are quite commonly voiced at witness examinations, are objections to a witness question. And So a question formulated to the witness that said witness should answer. And one way to analyze objections and one way to analyze the questions and what objection to pick, so this little test, is by first analyzing the question's surface, looking for trigger words like guess, could you guess, is it safe to conclude, is it safe to say. Those can be trigger words for an objection. Then one could look at the tone. Is it overly sharp? Does the tone attack my witness? And finally, is my witness even qualified to answer to begin with? For example, if the question asks for an expert opinion, so an opinion into something that your witness would have no way of knowing based on their lack of expertise, then they're not qualified to answer the question to begin with. And finally, after you've analyzed the question's surface, you can go on to the question's function. What's its purpose? What is it? What does counsel mean to do? And what is the purpose on record? How will the court see this purpose? Is the question meant to obtain facts, for example, from a witness? Or does counsel simply want to make a point by stating said question? Let's look at a few examples of analyzing the surface. What's the deal with this? Now, I'll leave you a little bit of time to think for yourself. You can pause this video, and if you're ready to resume, just click on unpause. Now, this question is vague on the surface. Its pretenses, so its framework, is formulated imprecisely. By asking this question, what's the deal with this, on, say, a witness examination, you're essentially giving the witness no reference point for what that question seeks. What's the deal with what? And what even do you mean with the deal? So what's the deal can refer to many things. Do I have to testify? Do I have to elaborate on something? The question surface is formulated vaguely, so the witness would at the very least attempt to guess what the meaning behind this question would be. At worst, the witness could be confused by this question. And let's look at the second example. Do you expect us to believe you? Once again, I'll give you some time. Pause the video. This one is argumentative. Instead of obtaining facts, instead of seeking to obtain facts from a witness, as should be, you are trying to make a point. You're trying to attack the witness character, the witness person, by asking this question. Do you expect us to believe you, you liar? As in implying that the witness has just lied. Notice how questions that are defective on the surface, so questions that don't work on the surface, like those two examples we just treated, also cripple their function. So also cripple their purpose. Even if, for example, the first question, what's the deal with this? Even if this question seeks to obtain new facts from the witness, because of the defect on the surface, the function of the question is crippled. So the purpose of this question cannot be realized, cannot be put into reality because of this defect on the surface. Let's look at a few questions based on their function. Could you give us your best guess? Now here you have a trigger word on the surface, guess, which implies that the function of this question, so the purpose, why are we asking this, isn't to obtain new facts from the witness, but instead lure the witness out to do some guesswork. The witness should always rely on their personal knowledge when they're testifying about something they witnessed, or their expert knowledge when they're testifying as an expert witness. They cannot rely on guesswork to answer questions because those are meant to be put in evidence. That simply calls for speculation. Oh, sorry. This question, what can you conclude about the defendant's motives? Again, we see a trigger word, conclude. Now, the question asks the witness to conclude about a fact of the case that is meant to be answered by lawyers. The subject of, well, the defendant's motives, and essentially their intent, is not meant to be answered by a witness. It's meant to be discussed, it's meant to be established by us lawyers during the trial, say, and well, ruled on by the court. A witness is simply not in the position to conclude something something in this direction. That's known as an adjudicative fact. It's not meant to be established by a witness, but it's meant to be established through lawyers by reviewing the evidence and establishing, okay, the defendant's motives are this and that, or we don't know what the defendant's motives are. It could have been unintentional, etc. So that question would call for a conclusion. Notice how a question function should somewhat revolve around introducing testimony to bring closer facts of a case. I wrote case, that's a typo on my end, but the question should seek to introduce facts to build foundation for your arguments. It should not make a point by attacking the witness, say, as we did here, do you expect us to believe you? But should instead seek to introduce facts into our evidence. Now, when examining witnesses, the law typically presumes their disposition towards a case. Disposition as in mindset, as in their view of the case, their testimony, how it will probably impact the case. And the law does so in a very simple way. Witnesses introduced by you, so by your party, are assumed to be friendly witnesses for your examination. So when you examine the witnesses that you introduce, they're assumed to be friendly witnesses because they're inclined to give favorable testimony. That's the general presumption, because you wouldn't be introducing a witness if the witness, well, wouldn't give you favorable testimony. And witnesses introduced by the adverse party are hostile witnesses. They're inclined to give unfavorable testimony. And this differentiation, this difference between friendly and hostile witnesses simply affects your objections. You can object to leading questions during direct examination, so during examinations of a friendly witness. So say a party A introduces witness A, a friendly witness, and party B can object to leading questions, whereas examinations of hostile witnesses, so cross examinations, allow leading questions. So you can see how friendly versus hostile witnesses affect your arsenal of objections. That's it for our video. Next up, we will treat preserving testimony. How can you save testimony for trial?